And with us here today is actually Mr. Ahmad Nizam Abbas, who will be sharing on the practical application of inheritance law, as well as the key principles, provisions, and considerations that govern estate distribution among Muslim individuals. Mr. Ahmad Nizam Abbas was admitted as an advocate and solicitor of the Supreme Court of Singapore in January 1994. And in 2013, he obtained a Master of Laws in Islamic Law and Finance from the Singapore Management University. He is the founder and managing director of Crescent Law Chambers, as mentioned previously. He has published several articles on Muslim law in Singapore, in particular jurisdictional issues between Family Justice Court and Sharia Court. He is also the co-curator of the module on Muslim family law at the Singapore University of Social Sciences. Mr. Ahmad Nizam is also active in community and social work and has been involved in diverse organizations such as Singapore's Central Singapore CDC, MUIS, and MEDAKI. He also held leadership position as the chairman of Trans Family Service Centre and president of MEDAKI Club. For his services in community work, Mr. Ahmad Nizam was also awarded the PBM, Singat Bakti Masyarakat or Public Service Medal from the President of Singapore during the 2007 National Awards. So, without further ado, please join me in welcoming Mr. Ahmad Nizam Abbas. Sorry, Mr. Ahmad Nizam.
Thank you. Okay, I'm not sure I can see everybody, so I'll stand at an angle where I can see most of you, right? But don't worry, behind the pillar, you all can also speak. Now, thank you, Umaira and PPIS for having me. I was just telling some of you just now, I think the last time I spoke here was more than 20 years ago, somewhere in the 1990s. Okay, so it's been a very long time. So I'm back, and I think this place has been done up so well now, okay, compared to the 1990s. Now, your slide was very interesting, the last part when you said about increasing awareness of inheritance. I completely agree. Based on anecdotal evidence on my clientele, right, in the last few years, I think 5 years ago, my type of caseload would be 80% divorces and 20% inheritance. I think now, if I were to just do a quick check, it is almost 50-50. So the number of inheritance files that we are handling has really, increased exponentially. Okay, and I think one of the reasons is also increasing awareness. People hear things, right, and think that, hey, how come in that family, right? How come in the end all the children got equal share? But I thought I was told that the boys must always get double of the girls. How did you do it? Right? Didn't we challenge you on that? No. Okay, these are things that I'm here to answer, very practical issues. Okay, and most of the time, the clients that come are those of a certain profile. They only have daughters, and they tend to worry a lot more, right? Because people tell them, you got no son, right? By tomorrow, ambil lah, a big share, and then your money all have to be given to a baby held by MUIS. Then they takut. Okay, things like that. Hey, everybody can speak English and Malay, right? So it's okay if I dabble with both. Okay. Now, so sorry, I got MUIS person at the back. So if I said something bad, you don't record me. Okay. So, but I think it's a fair comment. Yeah, I'm just saying what the public feels. Okay. So, well, that's actually somebody asked me, is there a book? And unfortunately, there's no book on the Singapore inheritance law when it comes to where family law and the civil laws all balanced. The closest I have is the book that I co-wrote with these two young ladies, Istiana and Mariam. Okay, the last chapter is on inheritance. So what I did in that book was that I got Ustad Irwan Hadi to write from the religious perspective, and then I wrote on the case laws in the civil courts. So we combined, so we co-wrote an article, and that's in the last chapter. The other chapters were all on divorces mainly. So at the time when I wrote, it was still the 80-20. So I think the next edition got to be more 50-50. Okay, so that's the background to it. Oh, sorry, you want me to click? Okay. Okay, so this one is understood. Now, this one, it may seem like a no-brainer, right? What is inheritance? But it's something that you pass down to other individuals. But I want you to reflect on this for a while and absorb this line, because you said something just now, right? If anything happens to you, why can I give to certain people? Okay. Now the key words here is things that are passed down. Okay. So in inheritance, if you have not made provisions during your lifetime in a certain manner, in compliance with certain laws, those will fall under hukum faraid, right? and it must go according to a prescription, because they are then subject to inheritance laws. But what you can do in your lifetime is think about what you want to give now. Because what you want to give now, there is actually no limit. But what you want to give after you are no more on this earth, there are limitations. And that is a very important distinction, right? Muiz calls it give inter vivos, okay, because it is give during your lifetime, they will not object. But if you make a will, then you are giving, or it's supposed to only take effect after you are no more. So the passing happens after you are no more. That one is subject to strict inheritance laws. Later, I'll give you a real life example of what I mean. So this very innocuous, harmless looking slide, the keyword is inheritance and then the word passed down. Okay. Now, so there is also something you need to know. Now, as a lawyer, we like to know what's the law, what section says this, right? AMLA stands for Administration of Muslim Law. I think you all know that in Singapore, we do recognize Muslim law, but it is very defined in AMLA. So, for example, marriages for Muslims, you come under AMLA. Divorces, you come under AMLA. Inheritance, okay? What about inheritance? Okay. Now, this is, lawyers like to draft things in a very weird manner lah. Okay, they could have just used simple English, right? Okay, but no, they had to put it in a negative. So there's nothing in AMLA that says you cannot do something which shall be in according to Muslim law. Sounds a bit confusing, right? Okay, they say you must follow Muslim law lah. What's so difficult, right? But no, okay, drafters, they all have a reason for saying that. Then you see 111. It's as if they're saying different things, but actually they're saying the same thing. If you look at it very carefully, right? So it says that no Muslim, right, can dispose of your property by will, except in accordance with Muslim law. So it's actually saying very much what 110 is also saying. You can make a will. That's what 110 is saying, right? Right? But you must follow Muslim law. 111 also says you cannot make a will unless you follow Muslim law. This is how they confuse you, and then you end up going to the lawyer's office and cannot charge a lot of money lah. Okay, for the lawyer to interpret this. Okay, but the keywords you need to know is that it's very simple. I simplify for you. If you are Muslim and you want to do a will, your distribution must follow Muslim law. The distribution, that means whether you want to give 1/3, 10%, 20%, it must follow Muslim law. Okay, but also remember, there's this line that says, subject to the restrictions imposed by the school of Muslim law. So there could be nuanced differences between the Shafi'i school, the Hanafi school, the Hanbali. They all better get the proper legal advice. In Singapore, the majority are Shafi'i. Okay, but you have also the Hanafi, and also depending on where your origins are, you could also be Hanbali and Maliki. Okay, later I'll do the case studies why that can be a problem. Okay, now what if there is no will? If there is no will, you still will be subjected to Muslim law. That's why I say very simple. They could have just summarized all this in one line. You Muslim, follow Muslim law. Finish. Okay, but no. Okay, but then they make it even more interesting, because this part now they say, as modified where applicable by Malay custom. Yes, it's in the law. I didn't make this up. No, you can check on Singapore statutes online. It's in the law. Okay, don't forget. You know why? Because we all need to remember history. This was drafted before 1968. It became law in 1968. So it was drafted many years before 1968. Okay. Now the reason being is that we just continued, right? What the law was prior to 1968. And if you remember, or our grandparents' time, right? Yeah, our grandparents' time, a lot of Muslim Singaporeans actually came from other parts of the region. So they came from Indonesia, ada Jawa kat sini, orang Maja, orang whatever lah. And then those who came from Borneo. So there's a good article you may want to Google one day by Ahmad Ibrahim about how is Muslim law in Singapore, right, spread. And he traced the history from the different regions in the region. And that's why in certain parts of Indonesia, from east to west, you have different inheritance laws. And then you go to Malaysia, you have the adat this, adat that, adat perpati, adat whatever, right? And then they have the different laws. So it was to cater for this. But That was 1968. Today, you try and use this in court, I think you will not succeed. Because you have lived in Singapore 50 years, 60 years, what Malay custom you want to apply to you? You just follow what everybody else also follows. But the politics of the day is always don't rock the boat, just leave it as it is. Because you never know, there could be a 150-year-old man somewhere, right? And he says, I want you all to follow my Malay custom. Okay? And also there was a case in court in 2010 where the parties were actually not Malays, but they were Yemenis. But they wanted to apply the adat propate. And the High Court said, it does not apply to you. You're not Malay. That one is only for Malay. So all these quirks are okay, very interesting. Now, but this is now increasingly the clients that I get, right? They are very worried about this. You know why? Because 25% of people living in Singapore now are not Singaporeans, right? They are foreigners, and out of the 25%, quite a number are Muslims, you know, from the Middle East, from US and UK. And slowly they will have their lunch and dinner, and then someone will tell them, hey, you know that you're domiciled in Singapore, right? You've been resident here for 10 years, 12 years. Hey, when you pass away, your property will be taken by a Munis. And then they say, huh? Why? Because of this, Section 112. So then they start panicking and then they come to my office. Okay? Because technically it applies, okay? Because it says what? It's for Muslim domiciled in Singapore. It doesn't say Singaporean only, you know. If you're domiciled in Singapore, okay? That one you come to my website, I tell you the way out. Okay? Okay. So so therefore when we talk about Muslim inheritance in Singapore, okay, some of the keywords you need to know is Faraid is the Muslim law. I think everybody knows Faraid, right? That's the Muslim law inheritance. Sorry, I didn't acknowledge Muiz. I took that from your website. Okay, that picture okay, the Muiz website. Now I acknowledge that. Okay, so then certain instruments which I will go through later, which is a will and all that. Okay, it's okay, it's okay. I will follow your pace. Okay, so you're worried about timing, like I also. Okay, now, so what is Faraid? This one, I'm going to go very fast because I assume everybody knows all the prescribed shares, and then you can see, when you talk about Faraid, normally everybody only knows this important formula. Okay, the daughters get double the sons. Why? The sons get double the daughters. Yeah, testing you. Everybody you're alert now. Okay, and then the sons get double. So why do you think it's so? Exactly. And this is something that I'm so happy that in 2023, that is the first answer I get. But unfortunately, that's the first answer I get always from a woman.
Yes.
Exactly. Because when I ask in a forum where it's men, they say, because that's my entitlement. So it's very sad. Okay? So it's very sad. Hey, I'm an ally, don't worry. Okay, I'm with you. Okay. So I have to, like, when they come to my office, right, and I have to explain to them, you know, with greater proportion comes greater responsibility. You know, churi from Spider-Man line. Okay, so explain to them that actually is to help you to carry out your responsibility. So if you want to not be judged on Judgment Day adversely, you give your responsibility now, lah. Give your sister whatever portion you utilize. Okay, that's one of the formula we use, lah. Okay, now so I can also go and skip this. You can make that this always available, right? So I can skip this in the interest of time. This has to explain about before the Faraid. Okay, what's the difference and now? Okay, okay. Baitul Mal, I need to be very careful. There are Buddhist people here. Okay, sorry. So just know that Baitul Mal, okay, it is legislated for. It is in our law. And I'm saying this because I thought everybody knows it, but it turned out I had a big argument with a British lawyer on this because he didn't know, right? And it became a big dispute because, and he said, it's because you are a secular country. So don't bluff me that you have Baitul Mal. I said, we do, and I showed him this section 57. So for a non-Singaporean, that's why when they come to Singapore, right, they are actually very surprised that we have Baitul Mal. Okay, we do. Okay, if you want to know what Baitul Mal does, I think there's always the Google to tell you all that. Okay, this part you can see for yourself, right? Okay, now this part, so I can skip very fast. Actually, do you know that now Muslim family law is a compulsory subject for all lawyers? since 2023. Okay, since 2023, anyone who now does the Singapore bar, you need to know the basics of Muslim family law. Okay, and the reason why I'm reminded of that is because when I was teaching in the class, the student asked that, okay, if I, what do you call it? What if I kill, he said this, you know this line about if you kill, you cannot inherit, right? And then the student asked me in class, but what if I kill a stranger? What if I kill somebody else? Then I said, but you're not the person's beneficiary one. You don't even have a share in the first place, right? So it doesn't affect you. So sometimes we still have to think logically, okay? So you cannot kill from, you cannot inherit from the man you killed. So if you kill your father, right, you cannot claim from him, right? The share, okay? This one is important because, okay, of what you asked me just now during the break. So are there alternatives? Purposely, I anticipated your question. Okay, I knew you were coming. Okay, now, okay, so this is just now a sidetrack. Now, what happens when a person passes away? I need to explain this because you need to, for some of you who've never had a death in the family, right? Where the first thing is, but what to do? I don't know what to do. Okay, you cannot do anything until, as in the sharing estate, until you get a grant from the court. From the, now it's called the Family Justice Court. Okay, the word administrator and executor no need to be confused. Administrator is simply where there is no will. Okay, and executor where there's a will. So if in your will you have appointed someone as your executor, the person is an executor. If you have not done a will, then the person who is appointed by the court is called an administrator. Same functions, just different names.
What's the difference between this and LPA?
LPA, lasting power attorney. It is what do you call it? It is activated, right, during the person's lifetime.
Right.
Okay.
So if you have that, what's the difference with this?
Okay, and it is deactivated when the person passes away. So when you do an LPA to say that if something happens to me, if I become of unsound mind, I lose capacity, then my daughter takes over my affairs, right? That's fine during your lifetime. But the moment you are no more, then the LPA doesn't apply anymore. Okay, it expires. So I just explained the difference between a grant of probate and letters of administration. Always remember, that's why I use the word, I use capital letters when I use the word grant, because we always get people coming to our office and say, oh, I was told by the bank, I only need a lawyer's letter. And that's not true, no? Okay, it's not a lawyer's letter. You need a grant of letters of administration. This one is because once upon a time we used to be under the king, right? So we used under the British, so we inherited all the British terms. That's why you have grant of letters of administration and all. And for the root word of probate, you know what the root word of probate actually? It's not probe, no. It's just proof. So what happens is that, at first I also didn't know. So what happens is that, why they use the word grant of probate is that when you pass away and there's a will, your next of kin is supposed to submit the will to the court. They will validate the will. So then the will is proven to be valid. So that's why the word probate. Okay, so that's the only difference. And then that's where which court you go to is all based on value. If your assets are less than 3 million, you stay in the Family Justice Court. Above 3 million, you go to the High Court. Okay, that's all administrative. Okay, but this other thing you may have heard, the inheritance certificate. Have you heard of the inheritance certificate? Okay, you have, right? Okay, it's the Sijil Warisan. This is where when a Muslim passes away and you want to go to the Family Justice Court, right, to file, you will be told, no, you need, because you're Muslim, you need to give us your inheritance certificate first. Because the Family Justice Court is not going to calculate for you who gets how much. Okay, it will be the Sharia court. This one, you don't have to calculate on your own. Because all you need to do is go to this website, www.shariacourt.gov.sg. There is a trial calculator. You can go in and play around with it. How many times you like? You can say you have 4 children, 5 children, how many boys, how many girls, how many brothers, sisters. Not now, you don't have the whole. Okay. That one. Yeah, this one you just Google. Don't need to memorize the website. Just Google. Okay. So you can do as many times as you want. No limit and no charge. Okay. It's only when you want to apply formally for the inheritance certificate that there's a charge. You want to try just testing, right? You can try 100 times, no problem. Okay. So this is a very useful tool. People overseas also use our our website, okay, to do this. Last time, I still remember though, in the 1990s, before this came out, Singaporeans would travel all the way to Malaysia, up north, all, just to look for an ustad to calculate for them what is the faraid. Actually, no need. You just come to, you just go online and then the answer is there for you, pop nicely. Okay, no need to go to Malaysia to do all this. Okay. Okay. So now, Muslim wills, okay. What is the difference between a Muslim will and a non-Muslim will? Okay, the ink is still the same, same pen. Okay, or the typewriter, but the main difference, okay, will be in the distribution. This one I had to put in just because in the company of women, right? So I wanted to see whether some of you are triggered by a line like this. Okay, it is actually in Amla. No? Why isn't there in Amla a line that says husband can make a will? Why must there be a line in Amla that says that a woman can make a will? Think about it lah. This one also, I show this just because I'm at PPIS. Okay, so some of you may be triggered by this. Why is it we have a law that is so archaic, right? This pre-1968 law. Okay, you cannot find a line that says Muslim married men may with or without the concurrence of their wives by will of dispose of their property, but you have the other way around. Okay, I've always wondered about this, so I share. Huh?
We always.
Okay. Again, we need to go back to pre-1968. Why they put such a line that way? Okay. So what are the familiar things that you have in the will? Number one is why important to appoint an executor and trustee, because that is the person who is going to do the running around for you, going to do the court, going to court for you, and then later on going to sell your property for you and then distributing for you. Okay, so you can name a beneficiary if you want to, or you can name a close friend, or there are professional trustees as well. There are professional trust companies out there, but they're very expensive. Okay, so most people normally just appoint son, daughter, or wife. Okay, so guardian of children, this is a sticky point because this is where there is no divorce. Because if you do a divorce, this one actually of not much use, right? Because then the surviving parent will go back to court and just say, I want a court order on this. How can my wife just appoint that evil stepsister or something to be the guardian of the children, right? Okay, so the one with the asterisk is actually the most familiar to most people, right? You must have heard of this before, right? That for Muslims, you can only bequeath up to 1/3 of your estate. Okay, and the keywords is up to. So you can give 1% also can, 2% also can. It's only up to the 33.1 mark. Okay, and then the next one is who can you put in that 1/3? The golden rule is that you don't give in your 1/3 to those that form your faraid beneficiaries. You don't bequeath to people who are your natural children, right? Your parents and all, because they would already be inside the faraid. Okay, you are not allowed to. Okay, so who you look around your own family and say who is not covered under faraid? Adopted children, stepchildren, children out of wedlock. Okay, and of course you can give to friends who have taken good care of you. You know, that's not uncommon. Charitable organizations, mosques, okay, these are the common ones. Okay, now, but what happens, right, if you give in the 1/3 to those who are inside the faraid? Is it automatically, or is it always cannot do, or is there a way out? Huh?
It's already a portion, right?
No. What I'm saying is that the rule is that you can only give in the 1/3 those who are not in your faraid. But what if you actually do it in such a way that you end up giving to those who are faraid beneficiaries? Is there a way out? Yes. What's the way out? No. What's the way out? It's not just a will. You cannot will more than 1/3. But there's a way out. And the answer is in this book. Okay. I tell movies a bit because last Friday night they launched this book, Fatwa Singapura. It's a very good read. A collection of all. Sorry?
Latest adjusting.
This you only addition. This is volume 2. Volume 1 was on sciences, medical sciences. Volume 2 is on pewarisan dan perancangan keuangan. Okay. So the answer is in the book actually. Is this? You can if all the faraid benefits agree. And that is now one of the most common weapons. Sorry, wrong choice of word. One of the common tools that people use now. Okay, they get everybody to agree.
One of them not agree?
All must agree. Okay, that one also later can be done because what happens is that you give first, you distribute the efforts first, and then if that one person want to give to up to him already because it's already his money, but he cannot bind the other people who don't agree. Okay, itu dah once it's his money, up to him what he wants to do. Okay, so what is the effect of giving more than 1/3? Is the will automatically invalid? There's quite a bit of debate on this, and I, to be honest, I myself sometimes get a bit confused because some people say no, because you can actually the part is valid up to the 1/3 mark. It's only that the excess part goes back into the faraid pool. Okay, so you accidentally terkasih more than 1/3. It will still be valid up to the 1/3. Okay, and then the other school of thought is that it's not valid at all. But I think the first part is where I agree with because there's a High Court decision on it. There's a 2004 case called Ibrahim where the High Court ruled that all the way up to 1/3 is still valid. Okay, and lawyers we like to follow case law. Okay. So that's why we follow that.
I'm sorry, just a question.
Yes.
Mathematically, right, if you put 1/3, you set aside 1/3 to your non-faraid.
Yeah.
The remaining will still be 2/3, right?
Yes.
So there won't be any extra, right?
Yeah. No, what I'm saying is that there are people who make mistakes. So for example, they say I give 10% to A, 10% to B, 10% to C, 10% to D. That's 40%. But you can only give 33 per 1/3. So some mistakes are made that way. The other mistake they made is also by maybe at that point in time you make a will, right? They have a lot of money. So he said, I give 100,000 to A, 200,000 to this mosque, 500,000 to PPIS, tapi at the time of his death, actually he only had 1 million there. So that exceeds the 1/3 already one. You know, so how you draft the will actually got to be very careful. Okay. I had one client, very rich man at that time, and he wanted to make it like give 1% here, 2% here, 3% here, 4%. All I asked him was this, okay, who is going to be your executor? I said, my brother. Does your brother even know how much money you have? Don't know. How is your brother going to calculate all this? Yeah, I think he cannot. Yeah, I said, then don't you want to simplify your will to make sure that your brother does not accidentally go and give away more than 1/3. So there's a lot of this customization required lah. Okay, mana. Oh, they can claw back. The other beneficiaries, if they find out, they can claim back and say that actually belongs to me.
No, the money spent now.
Huh?
Sell the property and.
That's the settler. But usually sit everybody down, we try to settle the matter lah. Okay, but there are all these cases. Okay, so who are the people who normally do Muslim wills? These are the examples that from my own case files lah. So sorry if I offend anyone by the first line, right? Because there are a lot of people when I put Muslim with non-Muslim sources, how can it be? Kalau Muslim can only cover Muslim, right? But actually you realize there are people Muslims who do take the civil route and they marry under ROM, and they are the ones who come and see me and say, oh, I've married a non-Muslim, but now I realize that nothing can go to her because father will not go to her. She's a non-Muslim. Then I said, then if you want to give your non-Muslim spouse, but also remember you can only give up to 1/3. And then they say better than not giving at all, right? But of course, there's another way out later lah. So then can you? Okay. The other two is of course being a bit naughty. Can you will giving everything to Baitul Mal? because you don't like your brothers and sisters, or you don't like your children. Your children never look after you, right? So I don't want to give my children. I want to give everything to Baitumal because if go to Baitumal is for the community, right? Then in heaven I get points lah, right? Investment, right? So say I want to give everything to Baitumal. Cannot. Cannot. Wait, how do you say can? How do you say can? Because it's for good purpose, right? How do you say cannot? Okay, why cannot and why can? Okay, for can because it's for good purpose. Cannot because
The priority does apply, whether the one that does apply, the priority division does apply, whether you like it.
exactly. Okay, it is not for you, right, to decide. It is not for you. The 1/3, 2/3 rule is there, right? And it's not for you to decide that I want to circumvent this. Of course, there is another way out lah. It's not by way of will. You want to give now, give today. Give everything in your bank account to Baitul Mal now. Now go and give now. That you can do. But you cannot put it in the will that if I die, everything goes to Baitul Mal. Because then you are depriving the rightful priority beneficiaries. Even if the rightful priority beneficiaries are good for nothing, right? And have done nothing for you throughout their life. Because that's sometimes what we get. I get people coming to me, I want to do a will. I said, why? I got one son, 20 years ago, he walked out on me. I never even give me a single cent. I don't want him to have everything. I said, I can't do that. You cannot do that. Right?
Not fair.
Okay lah. It's not for me to decide what's fair or not fair lah. Okay? But on the reverse, can you will to not give anything to Baitul Mal? Same logic lah. Same answer. You cannot, right? You cannot do a will is that if right, upon my death, Baitul Mal is entitled to a certain share, do not give. You cannot do that. Okay? Now, so then we come about alternatives to doing a will. Okay, that one I follow first lah. Huh? Certain things I pause because there are also certain things you need to know about when you do a will, right? Is that you also need to make sure we follow the standard civil law for this. Okay, that all these things also apply to Muslims. Okay, and it's important. That's in our law lah, under the Wills Act. Okay, because that actually was drafted in, let's say, in a time of war. Okay, if your son at the age of 18 has to go and fight a war, the law will recognize that he is allowed to do a will. Okay, but if not, ordinarily, only if you're above 21. Okay, or see, it's one of those funny things that not many of us know, right? If your son wants to go out to live a life at the Jauh-Jauh in the don't know which ocean, Pacific Ocean or okay. So this one is always witnesses very important because sometimes we make a mistake. I have seen Muslim wills also declared invalid by the court because one of the witnesses is actually the wife or the son.
Cannot be family members.
Cannot be a beneficiary, yeah. It cannot be a beneficiary. It must be someone who has no interest, right? Okay, and it actually even more critical now is cannot even be the spouse of a beneficiary. Okay, that's why there was this big debate about the Lee Kuan Yew's lah, right? Where they said that actually this person should not have done the will because she is the spouse of a beneficiary. Things like that. So complicate matters. This one is always very interesting because although the civil law says it's revoked by marriage, right? But if they have 4 wives,
Sorry, the beneficiary, what about non-priority beneficiary? Can that person be a witness?
because you put her or him in the 1/3, right? Right? If you do a will, yeah, you make him a beneficiary by putting him as the recipient of the 1/3, right?
Okay.
Then he cannot be a beneficiary because he cannot be a witness because he is a beneficiary. You've made him into a beneficiary. Because
it's non-priority.
yeah, because the question of whether he influenced you to make him a beneficiary will arise, better not. So play safe. Your witnesses be very neutral. So that's why sometimes when people ask me to be a witness to a will, I get very sad. At least they don't want me to get anything. Yeah, why do you want me to be a witness? You're not giving me anything. So I always don't like, even the CPF nomination, I got a lot of friends asking me, hey, you become a witness to the CPF nomination. Don't give me. Okay, so like that. Hey, lawyers have gotten into trouble with about this also. There are lawyers who actually draft the will and make themselves into a witness. Okay, that one's serious trouble. Yes, it's come out in the papers. Okay, so now I take a short step back. I give you real life examples from my real files. These are real files, and then we do a test, okay, and see whether everything that I have said just now, whether we absorb or not. Okay, the first one, I give everything to my wife in accordance with Muslim law. Valid or not valid?
Valid.
Huh?
According to Muslim law.
So it's valid.
It's so conflicting, how to be valid?
Yeah.
So you disagree lah?
Yeah.
Okay.
In accordance with Muslim law.
But I think what is
So should we keep everything in accordance to a share, right? What it says.
I mean,
Yeah.
I give everything
This was actually drafted by a Muslim lawyer.
Okay.
Okay, this was drafted by a Muslim lawyer. Yes, by a lawyer. Okay, and it was held to be invalid because the wife does not inherit everything. Under hukum Farajid, the wife, there's no scenario that the wife inherits everything. So by trying to put the words in accordance with Muslim law, you are trying to make valid something that is not valid. So it's not valid. You cannot just say something is you cannot just validate something by saying it is so. It doesn't happen that way. Okay? If your wife tak dapat everything, but you cannot say I give everything to her and then in accordance with Muslim law. This was drafted by a Muslim lawyer. Okay, and he got in trouble because of this. So this is from a real case file. Okay, example number 1. So words does not solve everything. Okay, now the second one. If I do not return from Hajj, my house shall belong to my adopted daughter. Valid or not valid?
Provided it's not one, it's not more than 1/3.
Hey, you've been to all these classes before. You attend a lot. Okay, there's several issues here. Okay, if you break it down, deconstruct this, right? Be very careful of putting conditions. If I do not return from Hajj, okay, that became the problem in this case. It's a real life case. There was a house in Sembawang, okay, and in fact, the witness of the will was actually the former Mufti, Syed Isa, and yet it was held to be invalid. Okay, because the person who drafted this did return from Hajj. You see? And yet he puts, if I do not return from Hajj. So that becomes the problem, right? You put a condition. So if you come back from Hajj, tak pakai. That's number 1 problem. And number 2, my house shall belong to my adopted daughter, as your the best student in class always say. Yes, you need to know whether he's got other properties, right? But assuming he doesn't, he cannot give everything to her. If he had said, okay, that upon my return from Hajj, my daughter, something you have to do. So the wording is also so careful, and it's always dangerous to put conditions in.
But this is drafted by lawyer, so it's the lawyer's fault.
Okay, what? Okay, to be very honest with you, there are always complaints against lawyers. There are. Okay, and one of the, and when it comes to inheritance, actually a high proportion actually are the Muslim rules. And I know because the insurance company that deals with the indemnity for all lawyers, whenever it comes to Muslim inheritance, they will give me a call. And then they will ask me for my opinion. Then I have to write a whole opinion, whether or not valid or not valid. And then they decide whether to cover the lawyer or not. Things like that. So it's always very simple. So that's why I have real life examples to show you. These are all from real life files. Okay, of course I've changed the names lah. So the one house to Jalan Avocado, the other house at Banana Road, and the condo at Coconut Drive to my only son. Valid or not valid?
Depends on the value of the house.
Exactly. See, you all have personally very fastly, right? Very fast. You know now, right? About the 1/3, 2/3 rule. That you cannot just draft it without knowing what the guy has. Okay, or you put subject to the 1/3 rule or something, right? Okay, and also this one actually, if you want to save this, is not impossible. Okay, we have another instrument later we talk about called a deed of family arrangement and things like that, where you actually record an agreement between all the beneficiaries, and they agree to honor what father or mother wants to do.
So that will be inside the will.
It cannot be because the will cannot did the wanted total rule, right? But you can say that the family has done a deed of family arrangement, and that's what they want to do. I'll come to it. So that is now increasingly a very common tool now. A lot of lawyers will tell you about a deed of family arrangement. And even if you Google, I think Ustaz Hanif Hassan, okay, he has written articles on this and given newspaper interviews, actually saying that this is your way out. If you want to redistribute, you get the whole family to agree. Okay, especially in the case where you have girls and boys. Okay. Now, so real life examples are. Okay. Oh, I need to move faster. Okay. Now, real life examples. This is a 2002 High Court case. The facts: 1938, 1953, he passed away. Now, first of all, this is a long time ago, lah. Also, in the old days, it's a very British style that they do it, where they delay the distribution of the giving. But I just read just now while waiting for the class to start, okay, that there is a lot of fatwa that discourages this. Okay? Okay, on this. But this was the old days. This was, I think, before this fatwa came out. Okay? So this one, anyway, just for knowledge, how many houses do you think he left behind in Singapore? 10?
Developed already.
Yeah, oh, definitely. This is all 1930s. Okay, so but how many properties? And he passed away in Surabaya in 1953. So probably in the 1930s, 50s, how many houses do you think he had in Singapore? You said you one. Apa lah? Okay lah. Chinese don't like this number, but 44. I don't know. 44. He had 44 houses, and they were all big houses. Okay. Now all gone, I think. Okay. So if you see the name Basharil, maybe you ask around lah. Okay. Okay. So what happened was, he died in Indonesia, and the Indonesian inheritance said that he left behind to one wife and 6 children. But suddenly, other children came out and said, we are also his children. We are also his children. And then they say that he had a total of 5 wives. You know, maximum 4, right? But why you can have 5? Very sharp. Okay, it's 4 at one time. Okay, but no limit to the totality. Okay, in the lifetime. Okay, so this class too smart. Okay. So the problem is this. So what the judge had to do is really go back and dig and see whether or not the marriage were valid under Muslim law. You know how impractical this is, right? Because most of the witnesses all would be dead already. What? The imam, the Tok Kadi, all no more. The witnesses no more. But that's what you had to do, lah. Because if you can prove that it's a valid marriage, then that is a valid beneficiary. Okay, so the importance of keeping records and everything. Okay, so then this is the case where now a lot of people follow the deed of family arrangement because of this Court of Appeal decision. Because what happened was that before he passed away, he did a letter of wishes and he said, I want to make sure all of you get equal share. I don't care whether son or daughter, all equal share. Okay, and then he did pass away in 2003. 2 days later, they signed an agreement. We all agreed. Father said all boys and girls get the same, so all get the same. Okay? Then a will was discovered where it said something else. It said it followed Muslim law or something, right? Okay. Now, but the money is already distributed. And then a few months later, okay, one of the children, can you guess, right? The son or the daughter? Obvious, right? Obviously, the son now says, this is my entitlement, this is my hak. You all must follow Islamic law, right? Be good Muslims. Okay? He said, give me back my share. Right? But he signed the deed. Right? So what happened was this went to court. Okay? I cut a long story short. This is the only thing you need to know. Okay? Is the agreement valid or not to redistribute? And the Court of Appeal said there was an agreement, and that agreement is not inconsistent with Muslim law because they had experts who gave expert evidence, and the experts for the sisters actually said that in Islam there is a concept of a promise, and a promise is binding. You don't make a promise anyhow, no? And then later when it suits you, you say, hey, let's go back to Muslim law. No, it's binding. So that's why the deed of family enrichment now is very powerful. Very, very powerful. Especially, and I just did one last week in my office, a very high net worth Malay Muslim, and he asked me to give a lecture to his sons and daughters in front of the whole family. Because he wanted the boys to listen very carefully while he was doing, and we recorded the whole thing, because in case there would be a dispute in future, he wanted it to be shown, played back, that full information. The boys knew what they were signing and what they were agreeing to. Because he don't like, Imam father, I agreed to give to my sister. Then after that, father no more, he changed his mind. Yeah, so these are the modern technology. Just give me a few more minutes. Okay, so some of the things that you may have heard now is the word hiba, which literally just means gift. Okay, why is hiba also now increasingly in fashion? Because it's up to you what you want to give in your lifetime. There is no faraid involvement, because faraid only is activated after you are no more. So today you have 1 million in the bank, you want to give me, I accept. Even though I'm not your faraid beneficiary, right? It is a perfectly valid gift. It's a perfect gift. I give you my account number. Okay. Now, so a hiba is a gift. So you can and once you dispose of the gift, it's valid. So you give me, I accept. That's it. Okay. You can do it. You can give anything you want in your lifetime as long as it's yours to give, lah. Okay. You don't take from your niece and then give to me. Then your niece can trace back to me. Okay. Okay. So. Hold on. I'll come to it. Got. Okay. So the most common example, if you all have been following like CPF debates over the years, in the past, right, there was court cases where the old fatwa was that CPF monies are held by the nominee on trust, and then the nominee must distribute according to faraid. Okay, it's been revised since 2010 because if you read the fatwa, they use the principles of a gift. Okay, so I must give the Munis person here. Okay, it's in the book. It's also in the book. This fatwa is in the book. Okay, so and then this is the advice. This is all you can Google. It's on Munis website. Okay, what is a hiba? What is the fatwa on CPF monies? It's all there. Okay. Now, if you ask me what are the advantages of nomination, actually, it's very practical. For those of you who experience the death in the family, you would know, right? If there is a CPF nomination, you get your money within 2 weeks. Very fast. Okay, and now about PayNow, maybe even faster. Okay, but if you don't have a nomination, it may take months or even years if there's a family dispute, like it may take years. If you have nomination, 2 weeks, no? Whoever you nominate, I have my IC number. Within 2 weeks you will get. Okay? Don't call me and ask me to be a witness. Okay. Okay. So this, yes.
Simple nomination is called as gift, but you only get it when you die. When the person.
Yeah, but you're making, when you make the nomination, then you are giving now. It's just that CPF holds the money, they cannot release it.
Okay.
Okay. So okay. Because I don't have time, go and to the CPF website. Go to the Munis website and read on the fatwa. Is there. So hiba rukba is this is interesting because this is also another thing that is now very trendy. Okay.
Yeah.
Okay. So this is so that you absorb first. It's very unique. Okay. I am actually giving you and you accept the gift now, but if you pass away before me, it comes back to me. Okay? This one also is in the book, don't worry. Okay? Hey, I jual good lah today. Okay. But there's a problem. Okay? So, this problem was highlighted in this case in the High Court. Okay? There was this HDB flat that was owned by the mother. She passed away. Now, she actually did a hiba rukba giving the daughter the entire flat. But then the son said, no, it's invalid. It's invalid. Okay? The problem is that at the High Court said, look, it contravenes Section 50 of the HDB Act. Because under HDB Act, you need the prior written consent of HDB before you can do any disposal of the flat, any trust, any disposal. And because you did not get that written consent from HDB, so it's not a valid transfer. So the High Court voided that. So very dangerous. That sent a bit of shockwaves also lah. Okay, so and all the High Court did was that, look, I know that your MUIS fatwa says that the HIBA is valid, but the MUIS fatwa did not even mention anything about HDB Act. And it says, so we are not commenting on your fatwa. Okay, that's what the High Court. So but this is the danger. So now, you don't understand this one, huh? Okay. So now if you want to give your whole flat to your daughter, right?
My niece.
Okay, to your niece. Okay, you can do it by way of hibah rubah. But if it's a HDB, you need to write to HDB first and get them to consent. They need to approve. Because Section 50 says that you must get HDB approval first.
The law of HDB said you already have flat. I cannot deed it to them.
Correct. Okay, so there's a way out.
Oh.
You know the way out? Okay. HDB, yes, because HDB says that prohibition is only your niece cannot own the HDB house. Right? Because she already has a house of her own, so she cannot own a HDB house, right? But HDB says, but they do not object if you want to give her the sale proceeds of the house. So you don't give the whole house to her. You give the net proceeds of the sale to her. Sorry. Yeah. I think not enough people know about it. In fact, if you Google Berita Harian last year, actually I highlighted this. There was an article in Berita Harian about new instruments. And then there's my face at the bottom lah. And this was the case I highlighted because I said more people need to know about this. You can, but you need, very important. So what we are doing for a lot of times, we actually liaise with HDB, right, to get their approval. But let me tell you what, HDB approval is never overnight one.
Right.
I have been waiting for one case, I think 6-7 months to get approval. Huh? Okay, number one, it'll be easy if you are your flat is fully paid. If it's not fully paid, they ask you so many questions. What if it is not fully paid? What if this? What if that? A lot of questions they ask. Okay.
What I understand. Okay, mine is fully paid.
Okay.
Let's say I want to. I cannot deed the HDB to her.
Yes.
But I can deed the proceeds.
Yes.
To her.
Yes.
What do I do? I mean,
What is that?
what do you want to sell?
Go and see a lawyer to draft the deed for you, and ask the lawyer to write to HDB to get the approval for you. Yes. Yes.
Whatever it is.
Yes.
So,
Yes.
whatever happens.
So you still live in the flat. It is only the net sale proceeds after you are not around anymore, right? Then the executor will sell that flat, and then, right, the court will recognize that the recipient of the flat proceeds goes to your niece.
Go and see him again.
That is the way out. But again, you need the HDB approval. No approval, very susah. So this.
I go to you.
Yeah.
You go to your job.
Where's the recorder? I'm not soliciting for clients. Okay. Yeah. But it's a very interesting case. Okay. This okay. If you want, you can Google this case, Haja, Maidin, and Roshan, and read the full judgment. It's a very short judgment by the judge. Okay. This judge 200 is famous for writing very short judgments. Okay. Yeah. If I know you email me, I give you the whole case. The book that I've been waving from just now is actually not for sale. Okay. It is distributed through donation to Wakaf Ilmu. So maybe later you can ask the MUIS in her personal capacity, right? How you can avail yourself of this book, okay? Okay, but it's a very useful book. But as I said, but if you want the information, you can still get it. But it's on the MUIS website. You just have to navigate, Okay, so I come to this instrument because I want to clarify any misconceptions about this instrument. This instrument is actually not very vogue anymore. Okay, it was around the 2000 to 2004 era. Okay, when a lot of people started to do nuzria. Then there was a High Court case, 2004. For those old enough to remember, I think it dominated the Berita Harian every day during the trial. It's still in there, right? No, it's 2004. 2004. Right? Oh no, oh you left already. Okay, so it was very hot news lah because what do you call it? Because of the very rare you hear a dispute like this. So basically, what is a nuzria? Is a vow. Okay, you vow to do something. Okay, you certain if I pass my exam, I will give $1 million to Mu'i, something like that lah. Okay, so now but in this case, right, there's a very unique provision, right? That okay, let you read. Okay. In fact, if you go to the MUIS website, they still have uploaded. Okay, this I should update this. This is so old. Okay, a sample of a nuzria. So all these things you don't have to worry. It's all inside the MUIS website. So they were actually encouraging even up to a few years ago. In fact, even today, you can still find the nuzria sample on the MUIS website, right? Okay. Then problem. Okay, because there was this man who passed away, and you can see, right, bin Ibrahim versus bin Ibrahim lah. So kesian lah, brother and brother fight the case. So the will was made up of 3 parts. 1/3 I give to mosque, a few mosques lah, and then 1/3 follow Faraid. And then he said another 1/3 I give a nuzria. Very confusing. And then under the nuzria, you will notice that people in the 2/3 are also inside there. See the son, the daughter, the daughter, the daughter. They already belong to that. So very confusing. This was a very confusing case. Okay, cut a long story. So okay, let me take this line by line. The first line was seriously the judge had to consider, was it actually something that will only be the property of somebody after he passed away, or are you giving during your lifetime? If it was an outright gift during the lifetime, the court said, then it will be valid. You can do anything you want in your lifetime. But the court said, no. The way in which it was worded means it will only be given to those people after you pass away. So it means it was a testamentary disposition. Disposition means you're giving, and testamentary is under a will. So what happened was that, okay, unfortunately, there was a MUIS fatwa, right, which actually encouraged the giving through a nuzria. But the judge highlighted, but your own fatwa is against your own section 60 of AMLA. Because under AMLA at section 60, you say that no wakaf or nazar can be more than 1/3. But how come the fatwa, the MUIS fatwa, tell people you can nuzria the whole house, everything you want to give, you can give. Okay? So again, I say a High Court judge is trained to only follow the law. And if you give me this law, I have to follow. That is the simple reasoning. The judgment is actually not very easy to read. It's over 100 pages, very complicated. So this is actually, I apologize if it's very summarized. Okay? But this was the problem. I've simplified it because as long as this is in AMLA, you cannot give more than 1/3, then it's invalid. And that was what happened in that case. Okay? In fact, I think over the weekend, for some of you who were interested on the Fatwa conference, right? And in Parliament just a few days ago, you would have heard that all these things about wakaf. The latest reading in Parliament is they have got round this by saying that this 1/3 does not apply to the wakaf lah. Something to that effect, right? Words to that effect. So they have actually now solved the problem for this present new term lah. This wakaf that you read, if you have read the papers in the last few days. But then they did not. This thing about the nuzria is still there. So as long as it is still in AMLA, lawyers are very scared to touch it. Because I don't want to take the risk. I draft a nuzria for you, and then after that, the other side, your brother what say? No, but it's more than 1/3, tak valid. And the High Court will agree. Okay, so a lot of cases that went after this Ibrahim's case, went before the court also said, no, we follow this section 60 because High Court say you follow section 60. So tak valid. So that's why lawyers, if you go to lawyers, a lot of them are very scared of doing nuzrias. There are some lawyers still doing nuzrias. They are a bit more high risk lah. I wouldn't have. Okay, to do. And anyway, now later we come to it. Now you don't need to do because there is another instrument. Okay, later when we go to joint tenancy. Okay, so this one just for general knowledge. I said because this has been in the news over the last 2-3 days in the newspapers. I think you can just go and read the papers lah. So basically, when you have heard the word wakaf when you grow up also, right? In fact, some of the time you travel around Singapore, itu rumah wakaf, itu this wakaf, because you have actually donated or given up that property literally back to God. Because under Islamic law, all property actually belongs to God. So we are just here on earth for a short time, you actually give back, and it's in perpetuity, no, means you cannot take it back. That is why, what do you call it? You know that once you give something under wakaf, you cannot then later give your niece anymore. No, is given is given. Okay. In fact, just for general knowledge, okay, if you travel around Singapore now, something very unique is that maybe 20 years ago, if you drive around Singapore, you'll find some houses, right, really very ketoprak state, because the old thinking was that if that property is wakaf, that is the property. You cannot do anything to that property. It remains like that, lah. So forever, the neighbors all very spruced up, but that house still look as if it belonged in the 1950s. It was only about, I remember when, 10 years ago, no, more than that, 15, 20 years ago, yeah, then there was a revisit of this thing, and Singapore was one of the first countries in the world to come out with a fatwa to say that actually you can change the character of the wakaf, because that is just the physical property. But what is more important is the value. So then you hear of Masjid Bencoolen, you know, Bencoolen Mosque. It used to be a single story at what do you call it, zinc top mosque near Bras Basah Road. Okay, I know because I was a Bras Basah school boy. Okay? So that was my mosque every Friday. Okay. Oh, you know everything. Okay, so that was my mosque every Friday. Very, very rundown. Now you go there, there is a service apartment, there is a restaurant, and then there is a mosque. Okay, and it's all under wakaf. So you can now convert, right? And then of course there are other properties in Beach Road, even the Red House in Tanjung Katong. Now you see things. In fact, Teluk Indah was I think the first condominium housing project to be from wakaf to become a condo. Now you have houses at mana Jalan Haji Salam. Haji Alas, Jalan. Wow, everything you ask us. Okay, very beautiful. So but you must know. So if you want to buy those type of properties, you must read the terms and conditions very carefully, because it's wakaf. So there's a lot of do's and don'ts inside there. Okay, be very careful. Okay, I don't want to say more lah. Wait, you all change your mind on buying the property, then scold me. Okay, so that's now the change. So I'm coming towards the end really. Now I've left joint tenancy to the last because I think this is something you all will affect you very directly. Okay, it's how we actually own our properties. Most couples, right, actually buy when they go to HDB or buy private. Almost by default, it is a joint tenancy. What's the other thing about a joint? If it's not joint tenancy, it's called a tenancy in common. Okay. Now, a joint tenancy is this. Okay. This is a bottle that I own with my wife. Can you actually separate the two? You cannot, right? So what is mine is hers. What is hers is mine. Okay. But in a tenancy in common, it's like this. This is mine, this is hers. Anything happens to me, right? This goes to my beneficiaries. Anything happens to her, this goes to her beneficiaries. But my share still remain there, and this one, her share still remain there. That's the big difference between a joint tenancy and a tenancy in common. Okay? So most husbands and wives, okay, buy houses under a joint tenancy because what is mine is yours and what is yours is mine. Okay? The people who buy tenancy in common could be friends, could be father and son, mother and daughter, whatever, right? Or two friends. Okay. If husband and wife buy tenancy in common, don't get suspicious. Also can. Okay. But it's just that you wonder why lah. Okay. But can. Nothing wrong with that. And maybe don't overthink. Okay. Okay. they just want the separate space. Okay, but this was the old fatwa, the pre-2019 fatwa. Actually, there was a line that says that the right of survivorship, right, does not exist in Islamic law. So, if anything happens to one person, right, it does not go to the other person. It says that you hold this on trust for all the faraid beneficiaries. And that was the problem. That was the problem under the old fatwa, because under the law of the land, right, the survivorship, actually everything belongs to the wife now, or the surviving spouse. Okay, so I give you a bit of background. So what happened in this case? Where was this case? Okay, sorry, I cut too short. So what happened in this case was that when the man passed away, everything went to the wife. And then the wife, because now she's the sole owner, right? She then gave to her daughters. Okay? But the brother of the deceased objected and said, no, you're not allowed to do that. Okay? Because under Faraid, I should get X share of that house. So they fought all the way to the High Court and then to the Court of Appeal. And the Court and the High Court and the Court of Appeal made it very clear, okay, that in Singapore, all of you are subjected to the Land Titles Act, whether you're Muslim or not Muslim. Your house is still a house. It's still made of cement and whatever, concrete. Okay? So, but then again, problem, right? Because at the beginning of the slide, for those who were awake just now, it says that the inheritance of a Muslim must follow Muslim law. So why is it that you don't then, you have this situation? You know what the answer to that? What was the Court of Appeal's answer to that? Very simple. Okay, he said this. This house, when you pass away, does not, you don't transfer to the husband. It simply morphs from two owners become one owner. I say this again slowly. There is no actual transfer from the husband, the deceased, to the wife. What happens is that this house simply like magic show. It morphs from two owners become one owner. That is what happens. There is no passing. There is no giving from husband to wife. It's just yours already, with no passing. And that's a very important point. When I teach this subject in law school, right, I tell the students, anyone who uses the word, when A passes away, the property passes from A to B, I fail the person. You don't pass it on. It morphs. It changes its character. Why is it important? Morph, M-O-R-T-H. You know Mighty Morphin Power Ranger? Okay. Morph. Okay, morph. It morphs. Okay, metamorphosize. Okay. Why is this important as a concept to understand? Because, and this is how the Court of Appeal said it, because it is not an inheritance property. And in a property subject to Muslim law of inheritance must be something that is available to be distributed. But because your house has morphed from two owners to one owner, right, there is nothing to pass. That's why it doesn't go to the brother. That's why it doesn't go to other people. As long as it's joint tenancy. That is why it's really the concept of what is yours is mine and mine is yours. And if one of us passes away, the other one is completely the owner. You do not split, you do not break the house into two. Unlike a tenancy in common. A tenancy in common, when you sign the document, when you buy, right, you actually say, I own 50%, she owns 50%. Or father and daughter sometimes 90-10. Or 80-20, 70-30, up to you how you want to hold it.
I mean, that's father of the son. Okay?
Yeah.
But normally when a couple, when they buy a house with, let's say HDB, it's automatically joint tenancy, or do you choose joint tenancy?
Okay. The problem is this, okay, to be very honest with you, on the ground, sometimes we never ask. But, right, and the estate agent also don't tell you, and the history also don't tell you.
Correct.
But you know, as a matter of practice, the default is always joint tenancy if your husband and wife. The HDB officer sitting at that desk always assume it's just joint tenancy. And you also sign as joint tenancy.
But you should check.
You should check.
Is there a way when you can change from tenancy to
Tenancy in common,
Is there a
yes.
way to change?
Yes. They at law you call it, you need to sever, you need to cut off the joint tenancy and change it into a tenancy in common. But there are rules on how to do it because you need to file it at the Land Titles Act because you need to be registered. Otherwise, there's no proof. You need to give notice to your spouse, for example. I want to change from joint tenancy to tenancy in common.
I mean, because this is supposed to be a session to educate
Ah,
our women,
yeah.
women this sort of thing.
Okay.
So, what is the context that, okay, women go for joint tenancy, what is the context of?
What's the benefits of a joint tenancy?
Tenancy in common, yeah, that kind of.
Okay.
Yeah.
Good question. One benefit of a joint tenancy is that if your husband is the one that passed away, right, you are now the 100% owner of the house. 100%. You own it in your sole name without having to do anything. It is an operation of law. You don't even have to apply to court, right? You just need a death certificate, go to HDB and file what is known as the notice of death. On the spot, they will change the land title for you, will put a stamp at the back of your title deed saying that now you're the sole owner of the house. Okay? Therefore, you cannot be kicked out. But, and also, if your brother-in-law, who last time was so nice to you, suddenly now come knocking at your door, say, I want my share. Because Father A say, I have a share in the house, right? You can tell him to get lost. Seriously. Because he will say, I will take you to court. Take now. Because the court of appeal already say it belongs to the wife now. But in those days, and if you read the movies fatwa on your website, right? The problem was a lot of women were pressurized by the husband's family members, give me my share. And they did not know better. So they were told that this is hukum. You know, you cannot transgress God's law. So they had no choice but to sell. And then where they live? From one rental house to another rental house. And then the matrimonial home, the brother-in-law take the money and go enjoy.
It's also to siblings, right?
Yes.
Let's say sister has joint tenancy with
Yes.
parents, and then the brother comes knocking, same thing. Right?
Yeah, okay. That one a bit more you need some safeguards because that's why when you buy father and daughter, you need to think about what are the consequences later on. That one better to buy tenancy in common actually, so that you prevent these disputes. But if you buy joint tenancy, then you make it very clear that what do you call it? You are really, yes. Because there are also cases where the court has gone behind the joint tenancy. Because there are cases where actually joint tenancy between father and daughter, right, for convenience, but actually the father paid 99%, daughter paid maybe 1% only. But then the daughter take everything. So the other brothers and sisters will come and make noise, say, how come where's our share? These cases are the ones that you read in the newspapers. Then they really look behind why did they enter the joint tenancy in the first place? Was it a disguise for a trust actually? Right? Because the father couldn't buy on his own to put the daughter's name, all this convenience thing will come in.
So this is fatwa has already been set.
Okay, so this fatwa in 2019, now because of this, it continued to be a problem because the High Court said 2010, right? Even for Muslims, joint tenancy applies. But the fatwa said something else. But it took 9 years for the fatwa to be revised to now say that a joint tenancy contract is halal. Okay, and put an end to all these challenges. Okay, and again, it went back to a lot of first principles. And one of the principles they actually did is this. Okay, you sign a contract when you bought a property, and for a Muslim, right? When you sign a contract, you agree to be bound by that contract. So you cannot then use the excuse that, oh, but Muslim law says something else. You agree to that contract. So when you buy the property, you make sure you and husband and wife don't make sure whether you sign in joint tenancy or tenancy in common, or you buy it with your brother or sister or your friend. Okay, so that's how they have reconciled. Actually, I have oversimplified this point. You should actually take the time to Google the Buddhist fatwa on this. There's a very good explanation behind all this. But also to let you know, if you want to read the High Court case, it's called Shafiq's case. It's very complicated. It is very complicated. Okay, and to be honest with you, there are some things that were critical of the old fatwa also, including the statement that it is repugnant to Muslim law, this joint tenancy. Because what the High Court did was they did research on their own and they came up with page after page after page, to actually contradict the fatwa's position. And it was quite amazing, that the circular court can actually do their own research and then come up with opinion which was different from the fatwa. So it led to, cut a long story short, the fatwa committee even re-looking the whole issue, and then they have now reconciled the position. Okay, so now the position is now quite harmonized. But for many years, this was a big problem.
Yes.
Very big problem. In fact, even up to last year, I had a case where the woman came to see me, and said that the brother was knocking at her door. Okay, and I said why? Because they said they want their share of the deceased money, And she actually sold the flat already. She sold the flat right now. But guess what? What's the saving part? Not yet completion.
Oh.
She sold the flat already. Completion just like next month. So we quickly came in and wrote to the brother to say get lost. Seriously, we said that under the law, this is joint tenancy, everything now goes to the wife, and then we quoted the 2019 fatwa to say that also this is consistent with Muslim law, everything goes to the wife. Okay, you want to take us to court, take us to court. He backed off. Okay, but imagine if the woman didn't know. If she know how stressed she was now. She kept crying to us and she said that I sold my flat and can I get a court order to make sure that they don't know where I live also? Because I want to hide from them. I want to go to another part of Singapore where they cannot touch me, they don't know where I am everything. And she actually also, the CPF nomination right, she gave to them already. So I said, you want us to change back the money now? Claw back the money. Say, no need, I halalkan, because I stress. They took the CPF also.
Man.
I cannot disagree. Yeah, so
I think these things, especially joint tenancy, I think really need to get the women understand this.
Yeah.
Especially for the Muslim,
Yeah.
Really.
Actually, it works for husband and wife. But as what you say, if a father with a daughter, then I think, just my opinion, it is kind of unfairness in a way.
No, because like for me, my flat is me and my father, but my father was required to meet me, right? So I'm not joint basically, he's a tenant, and then I'm the main, so I pay for everything. So nobody can pay for me, right? Because it's mine.
But for my case, because we are sisters, but more percentage that I pay. So in a way, if anything happens, okay. Benefits is not only benefits also for sure. I have my fair share which I want to use that amount for my hereafter. So I lost that bit. It all goes to my sister. So that bit is a bit dicey in a way because I find there's unfairness in a way because I want for myself for the hereafter. So that bit I'm not sure, but for husband and wife, I do believe because the wife is the husband's responsibility. When he pass away, that responsibility has to be kept. And as you see, no calling, knocking, there's a lot of cases where families are broken and wife
But there is no one system that is foolproof. So even the joint tenancy, while it has decreased, softened the blow for a lot of women, we also hear anecdotally sad stories. I give you a real life example. I don't know how much time I don't want to hold anybody back. Those only just leave. It's okay. No offense taken. Now, so the thing is this. I did a case not too long ago where joint tenancy, the husband passed away. Okay, the husband passed away, and then the wife became the 100% owner, and there's more than one property. I think he had 3 properties. She became the 100% owner of all the properties. But guess what happened? They have 4 children, but guess what happened? 3 months later, right after she finished her Ida period, right?
She married.
Bingo.
That's where you lost. That's where
You see?
Once you married, then the
And-
husband also can, the new husband can get
And-
something.
You see, so she so she
So your husband family could go against
no,
her.
what happened was I haven't finished that. So so she remarried. Okay, I should have given some build up lah. Sorry. So what happened was when he passed away, right? Her old schoolmate came for the funeral and then. Every night came to the house, bacakan berdoa. Every night. Okay, 100 nights in a row. Then after the 100 nights, suddenly the children found out they went to Batam and got the nikah. Okay, and then after to make it even more foolproof, they came back to Singapore and went to ROMM and they got married at ROMM to even. And then the next thing the children found out, he told the wife to make him a joint tenant.
Scammer, scammer.
And it was his third marriage.
Oh my God.
And he's not divorced.
Oh my God. That's why he's a smart guy.
This is real life story. This is not bigamy, this is big of me. For him. So imagine the children. Now, if anything happens to the mother, this man takes everything. Yeah.
This is where joint tenancy.
Can also be, yes.
There's always a devil's advocate.
Yes.
I'm saying that can we put it in terms of conditions for this joint tenancy to be executed? Cannot.
Cannot.
It cannot.
When you, as I said, the only other way is by way of a trust, in the sense that, like father and daughter, for example, the 99-1, then you go and fight, you got to prove that actually it was just a matter of convenience. But very rare, because in Singapore we are such a country where you are bound by what you sign. So unless you are like old man.
This case that the woman then got married and then the man make him as a joint tenancy. That means the children will not have anything.
Yes.
Yeah.
That's the problem. So we tried to rescue, but how? We even went to court, right, to challenge the marriage.
Yeah, because it buttons.
No, but the one in ROM, we couldn't manage to challenge the Singapore marriage, no? We got the wali to actually file an appeal to actually nullify the Singapore marriage. The appeal was, I can do anything. She's a grown woman. She's a grown woman, she's sane. We cannot intervene.
But can we undo influence?
Yeah, we tried that.
To
But she says no under influence.
Yeah.
Yeah, she knew what she was doing.
And she was happy with the way it
I mean, what about, she never think of the children?
Okay, this one we say man, right? So no, I am let's take this moment. Love. Yes. Love. She was guided by love. Yes.
Love is blind.
Sorry?
So that means the man married the woman.
Yeah.
The intention of.
Of course.
We will never know, but for him he said it was love lah. That was, I knew her from school. Huh?
Just lie
Yeah, I mean, to any objective observer, it cannot be so fast, right? And he got 2 wives already.
So this is the third one.
This is his third wife. He's got charisma lah. This one probably Astro will already play it already lah. This sounds very much like something you catch on Astro. But it's a real life. And to be honest with you, the Fatwa committee, when they were deliberating the 2019 Fatwa, they already thought about things like this. But they had to balance. They had to balance within the bigger picture, which is there are a lot more women who will be protected under the joint tenancy than these cases. Hopefully that these cases are just 1 here, 1 there. They had to balance that. They knew. To be honest, the Fatwa committee were aware of this.
I think this lesson is good for people who are going to prepare for marriage. You need to tell them this.
Otherwise, you must have prepared because they know for the marriage preparation course, right?
Prenuptial. Can do prenuptial. Set out the.
Amen.
We had a prenuptial
Yes, yes, okay. Yeah. Okay, usually when you, mm, during the interim period. Okay. Okay, this is a very good question, and obviously there must have been a case that happened before lah. So there is a precedent for it. Okay, and the precedent is that they follow the date of the order of court actually. Okay, that if on at the divorce date, the judge has said that you are dividing the property 50-50 or 70-30, right? From that date, actually the property is considered as no more a joint tenancy. But again, that's the problem that you also raised. But what if the judge also say the wife can take over the husband's share if she pays him a certain amount of money and it was not done? And that's the gray area. Then it's like, is it too late? She should have done it before she passed away. And so these are the one-off cases that something can be quite tragic. So that's why the law cannot protect every single scenario. Mm.
When was it like you were not like
2019. You can check on the website. I think it was early. It was, the date is always at the bottom of the fatwa itself. So if some of you look at that, you will be able to find it. But right, it's in the book. I think it's early. Okay, okay. It was in early 2019. Why? Sorry, you're talking about divorce now? Why? Okay.
Then my mom passed away, didn't manage to do the process. Now then, until the movie started, then we appeal until the movie started. The movie said that the house is not meant to be transferred to the estate, neither it is to be sold.
But what was the court order? What did the court order say?
The initial court order was meant for my mom to pay certain money, right?
Was for her to retain the flat if she pays him a certain money. But because it was not done yet, so it was considered as, yeah, so that was conditional one. That you're, it's still a joint tenancy. Yeah, because it no, it doesn't morph. Oh, sorry. What you're saying is that your mother passed away before she could pay off your father. So then your father became the sole owner of the flat. Yeah, because that paying off had not been executed yet. Not sometimes there's a grace period about 3 to 6 months, not more than that. So then your father would have to choose, right? Oh, he included her now as a joint tenant. Oh. So your stepmother has a house and your father has a house. Yes.
Legally, it's allowed, is it?
You have to check with HDB whether they will allow a married couple to each to hold each one of their own. I doubt so, but
I know for the Chinese one, they did not report.
Sorry?
They did not report any.
They got married.
Yeah.
You have to check with HDB. Yeah, because HDB will not allow you to own two, but this is different. Yeah, because it's there. Okay.
Sorry, I've got a question.
Yes.
In relation to this joint tenancy, let's say, for example, our late dad has passed on, so now the house belongs to our mom.
Okay.
So my mom it's all daughters. What is your suggestion? Do we follow do we need to do the faraid or the hibah? Yeah, because
I would suggest do the hibah rubah, but not to give the flat, but to give the sale proceeds of the flat.
Because it happened to my sister-in-law. She's she's the only surviving person. Her mom, dad passed on, and then the brother recently. So she was supposed to sell the house because there was no hiba or.
Okay, the danger is this, right? Okay,
Yeah.
I know Muiz is sitting near
Yes,
you.
yes, I
But
know, yes. So that was
because if you don't do anything,
yes.
you don't do anything,
Correct.
then Baitumal comes in with substantial share.
Correct.
Right?
So she only got half, and I don't know.
No, Baitumal. That one very sensitive. Muiz will never say go to Muiz is managed.
So because of that situation, we are more aware. So we
Yeah.
wanted to make sure that we are going the right way, or to.
If you do a hiba rukba, giving it to whoever,
Yeah.
right? Then you make sure you get the HDB approval, right? And then you make sure, and I think HDB will tell you, we will not consent if you are giving the flat. But we will not object if you are giving the net proceeds of the flat. Because they come from a position of public housing. They don't really care about the proceeds. They care that the eligibility, people who can hold a property. So it's very difficult to give.
So do we still need to draft a will for that? Or?
No, you draft a will to appoint an executor, and in the will you can say that I have done a hiba ruba, and then you can put the hiba ruba behind the will. So that it's two different documents side by side. So that there's no danger that you accidentally put inside the will disposition that will langgar the wanted to rule.
Yeah, I think this kind of thing you still need to have an advice from the.
Yeah.
Yeah, correct. Yeah, that time.
But it's good to know.
Yeah.
this knowledge.
Yeah.
So nowadays people, when they say they make a will only, don't be surprised lawyers say, no, a will is not enough. You need to make one will, right? And then you need to make the instrument.
Nizam, I
Yeah.
think you need to
Yeah.
share in terms of existing activities. I think these things people are not aware that you will go to Baitumal.
Okay, there was a slide just now, okay? So, let's just put it this way. There are certain situations in which Baitumal will have a share, right? And again, you can go and try the online calculator and find out whether Baitumal comes in or not. Now, the thing is this, if you want to appeal and say that can Baitumal not take its share, you can file a formal appeal. Okay, there's a prescribed form. Okay, and there's a very high level committee that will decide on the merits of your appeal. But it is a very high bar because they see themselves as doing a public duty, right? And it's a very important public duty, right? So in order for them to agree to your appeal, you need to prove that if they take the money, it will cause you extreme hardship, poverty. You are homeless, no, you got nothing. So if you come to Muiz and say that I want back my bungalow, right? My father then behind 3 bungalows. Sorry to say that, but I think it's very difficult for Muiz to say yes to you. Because where's the hardship? You have more than enough, right? So the bar is very high, but you will hear of cases where Muiz have returned back, where there is cases of genuine hardship, right? And in some cases, I heard, because I was also present at a seminar in which Muiz was a speaker, where they said that sometimes they only keep 1%, okay? Because they say they want to recognize that they still have a public duty to manage Baitumal, but they hear your hardship story. So symbolically, they say they just take 1%. Okay? And 99% of their share they can return to you. But the problem is, and I'm saying this very openly, even if Muiz is here or not, is that why the public is always very scared is because no one actually knows what are the factors that go behind the decision making. You know, like you go to court, right? The judge is bound to give you the written reasons. But Muiz, you normally don't know. And you go and Google Berita Hanan, you'll never know what are the reasons. And that's why the public always say, I'm scared, because I don't know whether my appeal will be approved or not. I only know this word poverty, hardship, that's all. But what's poverty to me is not poverty to Muiz. That's always the public feedback. I think they are used to listening to this. Dah biasa dengar, right? You get so many phone calls a year, right, on all this. Muiz,
I want to ask a question. Let's say I passed away. Then the house, because there's no will, nothing, let's say, Muiz or Baitumal.
no will,
No will.
then you are talking about intestate, no, which already the plan applies.
No. So normally, when you sell the flat, right, it goes back to CPF, no?
Depends. If you above 55, it won't.
Oh,
It goes to. It won't go back to CPF. If you're above 55.
oh, at least if it goes to CPF, then you have already got a nomination that I thought, so it's another way of.
No. Unless you're under, you turn back.
Okay.
Okay.
I'm gonna see you for the.
No. Okay.